My name is Suhana Kabir, and I'll be talking about the domestic violence and child abuse definition in Malaysia, as well as the available legal provisions. There are numerous definitions of domestic violence in Malaysia. Multiple interchangeable terms are used to describe domestic violence, including that is partner abuse, child abuse, and spouse abuse, among the others. Each term may have a distinct meaning, and selecting one definition over the other can affect how domestic violence is persecuted. However, this presentation will be focusing on the child abuse specifically. The Section 2 of the Domestic Violence Act provides the following acts which constitute to a child abuse: willingly or knowingly placing or attempting to place the victim in fear of physical injury, causing physical injury to the victim by such act which is known or ought to have been known would result in a physical injury, compelling the victim by force or threat to engage in any conduct or act, sexual or otherwise, from which the victim has the right to abstain, confining or detaining the victim against the victim's will, or causing mischief or destruction or damage to the property with the intent to cause or knowing that it is likely to cause distress or annoyance to the victim. In summary, domestic violence occurs when there is the use of force or the placement of fear of physical injury to the victim. Now, according to the World Health Organization on Child Abuse Prevention, the child abuse is defined as all forms of physical or emotional ill treatment, negligent treatment, sexual abuse, or any form of exploitation which could lead to actual or potential harm to the child's dignity, development, health or survival. The child maltreatment did not garner significant attention until the 1980s, when a handful of highly publicized incidents of the child abuse were brought to the forefront of the media coverage. Now, these factors served as the impetus for the government's implementation of the Child Protection Act 1991. Now, furthermore, the establishment of the One Stop Crisis Center in government hospitals across Malaysia since the mid 1998 has facilitated in the provision of the services to the victim of domestic violence, sexual assault, and child abuse. In April 1998, a hotline was launched by the government. Following the implementation of the Child Protection Act of 1991, physicians are obliged to report any suspected instances of child abuse to the appropriate governing bodies. In an effort to address the concerns pertaining to the children more efficiently, the Child Act of 2001 has been replaced by the Child Protection Act 1991. Moving on to the provisions which protects the children from child abuse. The laws which protect the children from domestic violence include Domestic Violence Act, the Child 2001, and the Sexual Offences Against Children Act 2017. As per the Child Act 2001, the term child abuse encompasses situations where a child has been or is significant danger of being subjected to physical or emotional harm, sexual abuse, or neglect in terms of receiving proper treatment, food, shelter, clothing, medical attention, supervision, and safety. Additionally, the Act also considers abandonment or situations where the child is left on the street or exploited for begging by their guardians or parents as forms of child abuse. In accordance with the Section 31 of the Child Act 2001, it is illegal for an adult to subject a child to maltreatment, neglect, abandonment, or exposure that is likely to result in physical or emotional harm. Now, Section 31, subsection 1 further defines that any person who, being a person having the care of a child, abuses, neglects, abandons or exposes the child or acts negligently in any manner likely to cause him physical or emotional injury, or causes or permits him to be so abused, neglected, abandoned, or exposed, or sexually abuses the child, or causes or permits him to be so abused, commits an offense, and shall, on conviction, be liable to a fine not exceeding 50,000 ringgit, or to imprisonment for a term for not exceeding 20 years, or both. The Sexual Offenses Against Children Act 2017 is an act to provide for certain sexual offenses against children and their punishment, in addition to other sexual offenses against children and their punishment in other written laws, and in relation to it, provide for administration of justice for children and connected matters. Section 2, subsection 1 states that the Act shall apply to a child who is under the age of 18 years, and where the Act relates to any other written law, to a child of such age as specified in such written law. Section 2 provides that any reference to a child in respect of any offense under this Act, or any offense specified in the schedule where the victim is a child, shall include a person whom an accused believes is a person of or under the age as specified in the respective provisions of such offenses.
Having knowledge of the legal provision, let's dive into causes of child abuse along with statistics in Malaysia. The Department of Social Welfare in Malaysia has compiled data on child abuse and allowed public access on a yearly basis. The data collected from 1989 to 2019 recorded more than 2,000% increase in child abuse cases in a span of 30 years. This heartbreaking figure does not include cases which are still undiscovered and remain hidden. Our group has compared a statistic from 2017 to 2020, which is the latest edition, and observed the trend in this type of domestic violence. From 2017 to 2019, there was a continued increase in reported cases, which went up to as high as 6,382 cases. However, in the year of 2020, where COVID-19, a global outbreak of an infectious disease, first came into Malaysia, the Department of Social Welfare recorded an unexpected decrease in the case of child abuse with a total of 5,858 cases. Other than in Malaysia, there was also a global decline in reported child abuse cases. Researchers have different thoughts on these figures. Some believe that the financial assistance provided by government have lifted the burdens on family, thus reducing child abuse. On the other hand, some believe that the number of cases remained the same or became worse, but it was concealed within the four walls. Online classes and movement control orders may have deprived outsiders and teachers the chance of identifying child abuse, thus reporting to the authorities. Our group is of the view that the figure on child abuse does not reflect the severity of child abuse in Malaysia. However, knowing the cause of abuse helps tackle the issue to the ground. So what then are the factors of child abuse in Malaysia? Research said that a higher economic growth in a country could lead to a rise in the cases of child abuse. A concept called the Kuznets curve was adopted. It suggests that when economic growth, cases on child abuse will increase, but this is not permanent, as the cases will decline if the economy continues to grow. It was suggested that this U-shaped curve could be the result of humans' ability to adapt. When the economy is growing, people in the nation are required to put in more effort, and it becomes harder to maintain work-life balance. Thus, those who are dependent on others will be neglected, or worse, they could be physically abused. However, the cases will decline as shown when the countries find a way to adapt to the economic growth, either by way of managing stress via policies such as work from home, or through technology advancement, which makes working easier. The factor of economic growth correlates with the factor of female labor force participation. To achieve higher economic growth, it is necessary to have more people working and increasing the productivity of each business. However, research indicates that higher female labor force participation rate leads to higher reported cases on child abuse. This is the same as a principle in economic growth, in the sense that female workers find it hard to work and take care of their children at the same time. Working mothers may leave their children at care center or hire a babysitter which may cause their children to fall prey to child abuse, as the year 2020 alone recorded 283 cases committed by babysitters. Nevertheless, this does not mean that if people stay unemployed, the child abuse rate would decrease. On the contrary, unemployment contributed to the increase in child abuse cases because of the stress and fear that attach with it. The unemployed are afraid that they will be unable to afford the living costs of their family, and the stress may be the very reason why they abuse their child. It is notable that the 4 years comparison made between 2017 to 2020 had one significant similarity. That is, the main group of perpetrators who contributed to most cases is the biological mother of the child, followed by biological father of the child. The statistic also shows that family dispute has always been one of the top 3 reasons of child abuse. This brings us to another cause of abuse, which is divorce. When parents divorce, children who do not understand the situation would be confused as to the change in lifestyle and the difference between their own family and other family. For those who understand the situation, they will inevitably feel depressed and may even have the incorrect thoughts that they are the reason behind their parents' divorce. This creates a significant amount of stress and may have a long-term negative impact on the child. The chairman of the Focus on Family Malaysia suggested that children affected by divorce may turn to bad coping mechanisms such as being with the wrong group of friends or misuse of drugs to cope with the pain associated. These are some, but not all, of the causes of child abuse in Malaysia. Certain forms of child abuse will not leave any physical scar, or even if it does, it will fade away as time passes. But the impact of abuse will remain forever, thus there is a need to put more focus on the issue of child abuse. I'll pass the floor to my teammate who will talk about the support mechanism on child abuse.
For rights to have meaning, effective remedies must be available to redress violation towards children. I'm Tanjing Ru. Besides the law, there are various support mechanisms to protect the child from child abuse. Malaysia acceded to the CRC in 1995. As one of the state parties, Malaysia is under a duty to provide protection to every child within its jurisdiction from any kind of physical or mental violence under Article 19 of the CRC. The United Nations has introduced a series of more stringent enforcement mechanisms. The state parties are required to submit a self-report to the committee within 2 years of the convention comes into effect, which is under Article 44 sub 1 sub A, and thereafter every 5 years. Nevertheless, the self-reporting mechanism has been questioned of its authenticity and reliability. It relies on the state parties' self-concerns, as it would be impossible and inadequate for the committee to obtain a full image of the real condition of the children in the state based on a simple report. Nevertheless, with the adoption of the optional protocol to the CRC on the communications procedures, a complaints mechanism was introduced in 2011 for children whose basic rights have been affected to seek justice outside the domestic judicial system. It ensures the children would not encounter any human rights violation, ill treatment, or intimidation after submitting complaints to the committee under Article 4 sub 1. The victim will then receive necessary interim measures by the state party upon the request of the committee, which is considered necessary in their particular circumstances to avoid any irreversible damage to the child under Article 6. Apart from that, the state party has to submit a written response to explain to the committee if any appropriate measures have been taken by the administration in light of the recommendations of the committee under Article 11 sub 2 within a duration of 6 months. Other than the support mechanism provided by the CRC, we also have domestic mechanism to protect our children suffering from domestic violence. The duty of mandatory reporting has been imposed in the Child Act 2001 from Section 27 to 29 respectively. Medical officers or registered medical practitioners, family members, and childcare providers must report immediately to a protector if he or she has reasonable belief that the children had suffered with physical or mental violence due to being neglected, ill-treated, exposed, abandoned, or sexually abused. Any part who fails to inform would be liable to a fine not exceeding 5,000 ringgit or to imprisonment for a term not exceeding 2 years or to both. The child will then be taken into temporary custody if the protector or any police officer is satisfied on reasonable grounds that the child is in need of care and protection under Section 18, unless such action is in contrary with the best interest of the child. The issue concerned is whether the reporting system is overall effective as a supporting mechanism. Firstly, the mandatory obligation is not enforced on others who are not family members, doctors, or childminders. Since adolescents and children spend most of their time in school, it is reasonable to presume that the educators have more access to children as compared to the others. Law reform is needed to include educators in this mandatory reporting obligation. Other than that, Section 116 has provided protections to the mandatory reporters and informers. The idea is to encourage people not to step aside if they have reasonable belief that the child is in need of protection and care. For instance, the informers shall not be liable for defamation in respect of giving such information under Section 116 sub 1. Besides, their personal identity and information shall remain undisclosed in any civil or criminal proceeding unless in exceptional circumstances in view of justice, the proceedings cannot be done without the disclosure of the informers. The protections are important as most people are unwilling to risk themselves in danger. If the informers believe they will not encounter any troubles or revenge taken by the offender, it is more likely for them to make a report to the protector. In short, there's still room of improvement of the reporting system, yet it remains effective overall. Nextly, mass media reporting of children is strictly prohibited as laid down in Section 15 of the Child Act 2001 to secure the welfare and interests of the child. Any media or publisher who reveals the name, address, or educational institution, picture, or any information which may lead to the disclosure of the child identity shall be liable to an imprisonment not exceeding 5 years or fine not exceeding 10,000 or both. This mechanism is necessary to safeguard children who are uniquely vulnerable as compared to the adults from suffering with psychological distress or trauma if their identities are exposed through the media. Nextly, a child witness has never been presumed as a reliable witness. As underlined in Section 133A of the Evidence Act 1950, a mandatory corroboration requirement is imposed on the unsworn evidence provided by child witnesses of tender years. This simply means that the evidence provided by the children alone is insufficient to convict the offender unless being corroborated with material evidence which is admissible and being independent from the statement requiring to be corroborated. In the significant case of Muhammad Nakim bin Muhammad Yusuf against PP, where the conviction was quashed as the evidence provided by the child witness is not corroborated by any material evidence. The reason for mandatory corroboration was illustrated by Thompson C.J. because the evidence given by children is suspicious as there is always a risk that a child may not fully comprehend the meaning of taking an oath and they may have difficulty distinguishing between reality and fantasy. However, this principle has brought disadvantages in dealing with sexual abuse cases. The conviction is nearly impossible as sexual appeal cases normally happen privately between the accused and the child, where corroboration is almost non-existent. This was further illustrated in the case of PP against Muhammad Torang, where the conviction was quashed as the children provided unsworn evidence and could not corroborate with each other. Therefore, reformation is needed to amend the mandatory corroboration rule imposed against the children. In light of the special status of children, a different proceeding is necessary if the victim himself has to provide evidence or show up in the court of law. A special alternative was introduced through the passing of Evidence of the Child Witness Act 2007, where its main objective was to reduce the trauma or distress experienced by children in court appearances. Unlike the old legislation, the child was to be treated as any adult witness if he can comprehend the nature of the question asked to him and is able to provide a rational response and under Section 118 of the Evidence Act 1950. The old mechanism was unfair and ineffective as it ignored the vulnerability and dependence of the children upon their guardians. The child witness had to retell the whole story of he or she being abused in front of the court and most frighteningly in front of the abuser. The child witness might choose to conceal the truth as facing the offender might remind him of the past traumatic experience. To reduce the stress of children when presenting evidence in the court, Section 3 of the 2007 legislation introduces a better alternative, allowing the children to provide evidence by either live link, video recording, or to put a screen between the child and the accused.
I'll be talking about the challenges in which we face when we are preventing domestic child abuse. So, although the acts as stated before have provided protection to children from domestic violence to some extent, there are still various issues regarding this topic. Firstly, the law is still weak to some extent. Although amendments have been made to the Domestic Violence Act 1994, the weaknesses of the law are still present. This is because domestic violence is not acknowledged as a specific crime, but its definition consists of a number of different types of abuses, that is, threatening to injure, causing actual injury, causing force and detention, and etc. against a child. So, for the abuse to be a crime under the Act, the victims must invoke the current legal provisions of the offences affecting the human body as stated in the Penal Code. And these offences are not reflective of the more serious and persistent, especially repetitive nature of domestic violence. Hence, injustice would occur as the perpetrators may be charged with a one-off crime. The sentence would not suffice for the repetitive nature of domestic violence. Furthermore, the legal enforcement of the DVA focuses more on physical abuse rather than non-physical abuse. Like physical abuse, emotional abuse will coexist with it. Although the Act does define sexual and psychological abuse, the police officials may only exercise the power of arrest when there is any physical injury caused by the perpetrator to the child. And this is provided for in Section 7 Sub 1 of the Act, which states that where the court is satisfied that some form of actual physical injury had occurred to the protected person, only then can the court attach the power of arrest to the protection order. Therefore, the children which suffer non-physical abuse would face issues to prove their case, as only physical evidence can be considered. Such non-physical abuse may include child neglect. As stated before, mandatory reporting is required if family members, doctors, and childminders have a reason to believe that the child is facing some form of domestic abuse. However, this is not imposed on other personnel such as teachers who play a significant role in the care of children. Teachers are important authorities in the lives of the children as well, due to the close contact between them when they are present in schools. Hence, abused children may be overlooked if there are obvious signs of abuse. Neighbors should be included as well, because with regards to this, even if there are such signs of physical abuse, society may view the injuries as mere punishment, which is the next point. So, due to the culture surrounding the victims, many disregard the abuse as mere punishment for misbehavior. Since most cultures in Malaysia depict abuse at a severe scale, most parents are not aware that the forms of corporal punishments are abusive. For example, parents may view corporal punishment as a way to educate the child. And as stated by Nora Dura Hamza in PP against Tan Keng Tong, overhitting and overbeating a child is the incorrect mechanism to educate him or her. Therefore, this leads to many unreported cases of child abuse. Underreporting may also be due to societal discrimination against children who have been abused, especially those who have been sexually abused. Since premarital sex and pregnancy outside of wedlock is socially discriminated in Malaysia, most children, especially those in their teenage years, do not seek help when they are abused out of fear of their parents' or guardians' anger. Even though the CRC provides such support to child victims, it is still weak to some extent as well. This is because the children may encounter difficulties when accessing the optional protocol due to the harsh admissibility criteria as underlined in Article 7. The 12-month rule imposed in Article 7 sub H triggers a negative impact on its effectiveness. The only exception to the general rule is if the victims are able to prove that it is impossible to submit the complaints within that time limit. However, this exception remains unclear as there is no developed case law or detailed guidelines provided in the optional protocol. Besides, any communication shall be inadmissible if the available domestic remedies have not yet been exhausted. unless the remedies are unreasonably prolonged or ineffective to bring justice to the victim as stated in subsection E. It creates obstacles for children because they may have the legal capacity to access the optional protocol, yet on the other hand, lack of legal capacity to request local remedies in domestic courts prior to submitting petitions to the committee. Moreover, there is no provision in the optional protocol to explain the broad term unreasonably prolonged or unlikely to bring justice. It remains unclear in what circumstances this case would fall within the exception in the admissibility criteria. In short, it is counterproductive if the optional protocol sets down the criteria which would exclude the children from accessing mechanisms, as most likely they have incompetent legal knowledge and capacity to launch legal procedures on their own behalf. Or even though reporting child abuse is in line with public policy as well, some scholars have feared that reporting itself may hurt the child further rather than resolve the issue at hand. This is due to the social stigmas as stated before. When the reports are not confidential, it may place humiliation, embarrassment, and uncomfortable feelings onto the child, and this would further damage the child psychologically. Hence, to this extent, the reporting of child abuse may not work in the best interest of the child wholly. And now I'll be passing this on to my group member. Thank you.
In conclusion, domestic violence toward children is still prevalent in society. Although there are many laws to support the mechanisms to prevent child domestic abuse, it is affirmed that there are many challenges as well. With regards to the weaknesses in the law as stated before, it is recommended that the Act specifically define domestic violence against children so the punishment can reflect the more serious nature of the crime rather than being charged as different crimes with lighter punishments. Similarly, the law should be improved by including specific provisions for the additional emotional abuse caused by the physical abuse as well. As for the issue of underreported cases, due to the lack of laws against other personnel as stated before, the legislative has to include mandatory reporting laws for other categories of persons in child's life as well. Specifically, if a child is in everyday contact with such personnel, and that is, for example, teachers, these professionals would also be required to be trained to identify the observable child abuse signs or symptoms. Even though this may be difficult to implement since the issue is with the culture of the nation, it is recommended that the citizens take steps to be educated on child abuse so that the mindset can be alerted. Since most cases go underreported due to this, society should have knowledge in the issues of children's development, traumas, and consequences of such maltreatment and children's right to prevent such abuse. This could be implemented through mandatory parenting courses. This would educate future parents in dealing with the misbehavior of children without corporal punishment or placing emotional distress on them. Furthermore, it is suggested for the complement procedure of the optional protocol under the CRC to be reformed to better protect children. It is recommended for a collective complement procedure to substitute its current system because it can improve access to the optional protocol for children. That means that an individual or organization can complain on behalf of a group of victims without being a victim themselves. This procedure would not require the consent of the victim as well, but this would not jeopardize the confidential of the victims. Lastly, to address the loophole in the Evidence Act 1950, it is suggested for Section 133A of the Act to repealed. As stated by K.C. Vaughan J. in Using Case, most Commonwealth countries have abolished similar laws, and therefore it is no longer viable in today's time. In abolishing such laws, children will have better access to the protection, and the harsh admissibility rule is no longer present.